When a person dies without a will or a trust in place, their estate has to go through probate. And if you do not even have a will in place, that means that the California state rules are going to be able to apply to your estate. A power of attorney is going to be able to have the ability to make legal and financial decisions on your behalf whenever you become incapacitated. Having these conversations often and as soon as possible actually makes things go much smoother in the long run. Welcome back to the Haynes Law Firm. Today I wanted to talk about a subject that I think that is super important for pretty much everyone out there. I want to talk about estate planning. I know that this is a topic that not everyone wants to have because it surrounds your own death or the death of people that you love. But what I can tell you is that having these conversations often and as soon as possible actually makes things go much smoother in the long run. When a person dies without a will or a trust in place, their estate has to go through probate. And if you do not even have a will in place, that means that the California state rules are going to be able to apply to your estate and give your estate to people via intestacy versus your own wishes. Intestacy means that you've died without any kind of will or trust, and therefore it's going to be split one half to your spouse if you are married, and then the remaining half is going to go in order of hierarchy. That means that if you have children, that one half will get split amongst those children, regardless if you've decided to not want to leave the same amount to each child, or if you have an estranged relationship with any of your children. If you do not have a relationship with your children, it doesn't matter. If you do not have children at the time of your death and you do not have a wife, then it will look to your parents to go via intestacy. If your parents have predeceased you, then it's going to look towards your brothers and your sisters. And what's even worse is if you do not have any living relatives, it can actually go back to the state, which means that anything that you've ever worked for can actually be taken away from the people that you would want it to go to and go back to the state. So with that in mind, you want to put in place your wishes via a will and an estate plan. The difference between a will and a trust is that if you have a will in place that explains all of your wishes and your wants and your desires with regards to who is going to execute your will and who is going to receive money via your beneficiaries and or any of your property, that can be placed into a will, but your will is still going to have to be probated in order for any one of your beneficiaries to receive your property. That means that the executor of your estate is going to have to go through approximately 18 months of court involvement in order to distribute your property to your beneficiaries. There are mandatory court fees as well as mandatory fees that go to your executor as well as to the attorney who assists your executor through the probate process that must be paid out of your estate before your beneficiaries receive any property and or money from your estate. This is super important to keep in mind because a lot of people believe that if they have a holographic will, that means a will that's written in your own handwriting, or even a will that's been prepared by an attorney or a paralegal or a will preparer and witnessed by two independent witnesses, that they're going to avoid the court altogether. But this is a misconception because if you only have a will in place and not a trust, your estate will still have to go through the probate process. So when you are having these conversations with your loved ones, it's important to consider having a full-blown estate plan that includes pour-over wills into your living trust, a power of attorney, an advanced healthcare directive, as well as a HIPAA authorization. The reason why it's important to have these 5 documents is because this is how you avoid probate. When you avoid probate, that means that the person who is administrating your estate does not have to go through the court system. They get to independently and outside of the court system administer your estate and divide and give each of your beneficiaries their allotted amount. This allows for you to save on court costs, the cost for the attorney to help administer your estate, as well as the administration fees that that can come for the executor executing your will. This does not take away any trustee fees that may be applicable under your wishes in your trust and will, because you can still account for making payment to the individual who's going to administer your estate after your passing. These are called trustee fees and they're still allowable. However, they will be less than would be included in all of the fees for the courts, attorneys, and your executor if you have to go through probate. This is equally the same as if you died without a will and have to go through probate via intestacy. Those same applicable fees will apply then. So if you're trying to save yourself as well as your estate and your beneficiaries money, it's better to actually invest ahead of time in a living will via an estate plan and pay the fee up front rather than having your estate incur significantly more fees through the probate process. An estate plan, as previously mentioned, includes 5 specific documents. The power of attorney. A power of attorney is a document that allows for you to identify someone to act in your behalf while you are incapacitated and or after your passing. A power of attorney is going to be able to have the ability to make legal and financial decisions on your behalf whenever you become incapacitated. That means that if you cannot make legal decisions, they're going to be able to assist you with your financing through banking, your stockbrokers, loan officers, to be able to assist you to sell your house, to enter into contracts, to handle your legal affairs if you are incapable of doing so. It is important to talk to the person in which you are nominating to be your power of attorney to make sure that they know what your wishes are so that they can execute them upon your incapacity. A power of attorney grants someone a significant amount of power over you. You can make a power of attorney exist even prior to your capacity, but it is typically standard to have the power of attorney go into existence at the time of your incapacity. You can also list what constitutes as an incapacity, and it is highly recommended that you do so. It is highly recommended that you have your treating physician write a letter attesting to your incapacity before a power of attorney would, in fact, go into an effect if you were only going to limit it to your incapacity. There are some circumstances in which individuals no longer want to deal with their financial affairs, and this is why you can identify a power of attorney without you actually being incapacitated, because you believe that they are just in a better position to protect you. This might be because there are certain children that are trying to come after you for your estate and you want to be protected against them because you feel like you are emotionally bound to them and that you might give them something that they don't actually really need or deserve, and that you want to identify someone to be able to make rational decisions on your behalf so that things are fair across the board. With regards to a power of attorney, that only is going to handle your legal and financial and contractual obligations. If you are looking to have someone be able to speak on your behalf regarding medical decisions, you also need what is called an advanced healthcare directive. In your advanced healthcare directive, you can actually list out what you are willing to accept for life-saving mechanisms, whether or not you have a DNR, what you want to do with your bodily organs, how you would like to have your body treated after your passing, and if you have any specific desires for your advanced healthcare directive to know upon your incapacity in a medical situation. So you can say that you would be putting on a feeding tube, whether or not you would be intubated, whether or not you will take life-saving blood infusions. All of this can be listed on your advanced healthcare directive, which can be kept on file with your primary care physician, as well as any other treating physicians that you may choose to give it to, held by yourself and held by your advanced healthcare director. It is exceedingly important that you have a conversation with the individual that you are electing to be your advanced healthcare directive so that they know what your wishes are, especially if you have to undergo any major surgery, if you're in any life-threatening accident, and whether or not you fall into a coma. If the individual does not have this information, it makes it very difficult for them to make informed and educated decisions. A part of them being able to have informed decisions is also nominating the same person as your HIPAA authorization as your advanced healthcare director. The reason why the two go hand in hand is that you don't want your advanced healthcare director to get into a situation where they do not have the entire medical history to be able to make the most informed decision. HIPAA authorization allows for doctors as well as medical facilities to give your protected medical information to an individual that is not yourself, that has been nominated by you, that would not otherwise violate the HIPAA laws that are in place in the United States. This allows for them to give you previous medical diagnosis, your medications that you're on, and any critical information that may be important for them to have prior to making life-altering decisions. If you're going to nominate someone to be your advanced healthcare director, make sure that you also have a HIPAA authorization and that you file that with your primary care physician and your home hospital in case of an emergency. Also, make sure that the individual that you have nominated has a copy of this information so that they can bring it with them upon them needing to act in your stead as your advanced healthcare director. There is a misconception that a power of attorney can make medical decisions. This is not true. They do not grant the same privileges, and many people have been turned away in the time of dire need when medical decisions need to be made. So make sure that if you are nominating people to make decisions for you, that you are covering all of your bases. And if there's a specific basis that you do not want to give to anyone else, that can be listed on your power of attorney and your advanced healthcare directive, whichever category it may come into. Just remember, when you are doing your estate plans are personal for a reason. That means you get to make all the decisions while you are of sound mind and when you've had the opportunity to explore all of your alternatives and all of the alternative people that you had in decision making when it came down to picking the right one. So don't be afraid to include anything and everything that you think is important to yourself, because at the end of the day, all of these decisions come down to what you want and you being able to articulate what you want prior to an emergency situation arising. So now that we've covered 3 of the most important documents that you can have in place while you are alive so that people can make decisions upon your incapacity, now I want to explain why it is so utterly important to have a living trust and to make sure that your trust is fully funded before your passing. A living trust is going to be a living, breathing, contractual agreement that actually has its own entity and gets to become something different upon your passing. Essentially, during your life, a living will is revocable. That means that if you change your mind, you have the ability to completely revoke it, to amend it, or to make revisions to your trust. That means that if in 5, 10, 15, 20 years, or even 1 year from now, you change your mind about your beneficiary designations or about your successor trustee, you have the ability to make amendments to that because you as a trustee still can revoke it and invoke a new one in its place. With regards to your living trust, it is going to have your specific social security number attached to it during your lifetime, and if necessary, because it has to be sustainable for multiple years, can be assigned its own taxable identification number upon your death. But that isn't something that you're going to need to worry about. That is something that your trustee will make a determination of upon your passing and whether or not distribution can be done in an efficient manner without the need for your trust to become its own taxable entity. So with that being said, when you go to establish your living trust, you need to first determine who is going to be your successor trustee. In married couples, this typically happens to be your partner for yourself and yourself for your partner, because they're going to be the one that easily can hold on to the property during the pendency of their life upon your passing, and then upon their passing for the beneficiaries to then receive the remaining portion of the estate. However, this does not have to be the case. You can identify anyone as your successor trustee, and there's nothing that's applicable in California community property law that says that your spouse has to be your successor trustee. The only thing that really matters at this juncture of the process is to identify someone who is going to be capable enough to execute your wishes upon your passing. You need to also talk to them to ensure that they are up to the job and that they are not immediately just going to pass it on and then leaving your trust to have to elect someone new. So make sure you have this important conversation with the individual individual that you're trusting to run your trust after your passing or upon your incapacity. A living trust becomes irrevocable upon your passing. That means that no one can go in and actually change the trust as it pertains to your wishes. The reason for this is because the mechanism is intended to preserve your wishes upon your death. Therefore, it disallows for anyone to come in thereafter to change your wishes. There are also provisions within the trust document itself that's going to allow for you to exclude individuals who come in on will contests that say that they don't believe that this is your actual wishes. That means that if they are named in your trust and will, and they contest it believing that they should get more, they can actually be specifically excluded altogether. This is also important to note because if you do not want this type of provision in your estate plan, then you need to specifically state that to your estate plan preparer. These are all important decisions to make, and I just want everyone to remember that these important decisions to make should be yours and yours alone. If you have specific desires about how you want your estate to be administered after your passing, don't be afraid to put it down, even if you think that on paper it may look unfair to certain beneficiaries. At the end of the day, no one gets to dictate how their estate gets distributed except for the trustee themselves. A living trust is also going to account for what happens if any of your beneficiaries pass before them. That means that if one of the named beneficiaries has predeceased you, you do need to determine what happens with their share of the estate. Is it going to go into a catch-all provision that's then going to be evenly distributed among all beneficiaries? Or is it going to pass to their heirs at law? Meaning if they have children, will their children share in their share? These are things to think about and to ask your estate plan preparer because you want to make sure that all of your bases are covered. You want to also make sure that there's always a catch-all provision, which means that if anything is left out that's not specifically stated, or if there's not a beneficiary to receive that portion of the estate, that there's a catch-all provision that is going to distribute it to someone that you care about rather than it usurping back to the government. Again, this is your opportunity to go around government regulations and to distribute your estate, both properties and money, to the individuals that you choose, not that the individuals that the government has chosen for you through intestacy laws. Another extremely important aspect to your living trust that allows for it to pass outside of probate is to make sure that your trust is fully funded. To fund a trust, you need to make either the beneficiaries to your stock accounts, to your retirement accounts, to your life insurance policies, the name of the trust, to change the bank account in your personal name to the name of the trust, or to transfer title to cars or properties or timeshares into the name of trusts. This is super important because if your trust is unfunded, then your trustee is going to have to go in to court on a Hague petition to be able to actually fund your trust post-death, and that creates a complication that you otherwise could have avoided. This is extremely important because you want to make sure that you're keeping your estate out of the probate court so that you do not have to pay any unnecessary fees after your passing. A rule of thumb is to suggest that once your will and trust have been completed, that you change the deed to your home or any property that you own into the name of the trust. This is the most secured version of being able to fund your trust. If you do not own any real property, then you want to make sure that the beneficiary designations on your accounts is the trust. And so if you do not have stocks or retirement accounts, then you're going to want to take the name of your bank account and change it into the name of the trust. This ensures that there is a paper trail that allows for your trustee to prove that the trust is actually funded, and therefore any other property that you acquire there afterwards still falls under the funded trust, even though not everything has been changed into the name of the trust. Remember, it only takes one specific transfer into the trust to fully fund your trust, but it is a best course of action to change as many as possible because that streamlines the process for your trustee upon your death. Another thing that you can do in your pour over will, which will essentially pour itself into the trust upon your passing, is to have a personal property memorandum. This is extremely important if you have sentimental items or items of for specific gifts that you want to give to specific individuals. Typically, these are going to be collectible items, jewelry, or even sometimes specific rental properties, aspects within the business, anything that you want to give in whole to someone rather than to divide it evenly or to give a percentage. You want to have this listed on your personal property memorandum. This is also important because this is one of the aspects of your trust that can be in your personal handwriting, and you can update it without the necessity to include your estate planning attorney in the process. You can keep a running list of the things that you want to give to certain people in your estate planning portfolio without having to completely amend your trust. This is important because there are certain times within your life that you may make a change that you say, you know what, this person no longer deserves to have this piece of jewelry because they, no longer care about jewelry, or you've fallen out with that person, or you no longer have that piece of jewelry, but you got a new one. Just allows for you to make those minute changes without having to incur fees to change it with your attorney. However, if you start to acquire large assets, percentage of ownerships in businesses, you start to get multiple cars, multiple bank accounts, these are things that you should discuss with your estate planning attorney so that they can decide whether or not it's necessary at that time to either amend your estate plan or to revoke it and start over. Also, if you come to a certain position where you no longer want your trustee to be your named successor trustee and you want to name a new individual, this is the time that you would need to contact your estate planning attorney so that a new trust that revokes your old trust can be completed. Just remember that this is your estate plan and therefore you get to drive the bus. Just because 5 years ago you decided that your aunt should be your trustee doesn't mean that today, in reviewing your estate plan, that you actually have to stick with your aunt. There is no contractual obligation during your life to stick with anything in your estate plan. Additionally, there is nothing during your life that automatically allows for your beneficiaries to be privy to any of the information contained in your will and trust. That information can be kept secret or shared freely depending on your own desires. But just remember, just because someone's listed as a beneficiary doesn't mean that they actually have a current legal interest or financial interest in your estate. It is a future interest, and therefore you can change it at any time. I cannot stress this enough because if without estate planning documents put into place when you are of sound mind and when you have the ability to express your desires and your wishes, you can find yourself in messy conservatorship proceedings, and you can also find yourself wasting time in courts during your life or having your beneficiaries and trustees waste a significant portion of their own lives in court thereafter your passing because you didn't want to have the hard conversations about what happens upon your passing. This is your time to learn that not talking about your death isn't worth the consequences thereof. You want to drive the bus during your life, you should also want to drive the bus upon your passing. So have the hard conversations with your family and book an appointment today to talk about your estate planning needs.